My name is John Eastman. I'm the Dean at the Chapman University School of Law. I'm also a constitutional law professor and scholar. And of course, my comments today are in my capacity as a constitutional scholar, not speaking on behalf of Chapman University. There are really two issues. There's a legal issue. Does the Constitution already mandate birthright citizenship? And then there's the policy issue. If it does, should we amend it to get rid of it? Or if it doesn't already mandate it, should we adopt it by statute because it makes good sense?
Right. And you've actually been called upon by Congress to address a variety of issues in terms of illegal immigration.
Indeed. In fact, this goes back to a brief I filed in the U.S. Supreme Court in the Yasser Hamdi case. Hamdi was one of the individuals that was detained in Afghanistan, taking up arms against the United States in our war there against Al-Qaeda and the Taliban. He was transferred to Guantanamo Bay, but when U.S. officials learned that he'd been born in Baton Rouge, Louisiana, while his parents were here on a short work visa, they began treating him as a citizen rather than an enemy combatant in Guantanamo. They transferred him to Norfolk, and his case went all the way to the Supreme Court. And we argued that understanding of citizenship, that just because he was born here made him a citizen, is wrong. And we started trying to lay the groundwork for revisiting what's been about a 50-year popular conception of what the Citizenship Clause requires. But as a result of that, Hamdi ended up being sent back to Saudi Arabia, and he renounced his citizenship. So the question of whether he was a citizen in the first place was never presented.
Oh, okay.
But we had laid the argument out there, and now members of Congress who are trying to grapple with comprehensive immigration reform,
Sure.
and looking at something like temporary guest worker programs. And they asked the obvious question: if you have guest worker programs and they're coming here with their families, what do you do with the kids born here if they're citizens? So all of a sudden, the birthright citizenship question is front and center on the logistics of comprehensive immigration reform. I think if I were to ask your audience to raise their hands, how many people think if you're born on U.S. soil, you're a citizen? Every hand in the room would go up. The text of the 14th Amendment is actually not quite what we think it is. It says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. Now, it's that last phrase, subject to the jurisdiction, where the fight is. Now, we also have this common understanding that when you come here to visit, you're subject to our jurisdiction. You have to obey our traffic laws. If you come from England, you ride on the right side of the road when you're here, not on the left side of the road. But the founders or the framers of the 14th Amendment had in mind two different notions of subject to the jurisdiction. There was what they called temporary or partial or territorial jurisdiction. You have to follow the laws in the place where you are.
Right.
But there was also this more complete or allegiance-owing jurisdiction, that you not only have to follow the laws, but that you owe allegiance to the sovereign. And that doesn't come by just visiting here. That comes by taking an oath of support, becoming part of the body politic. And it's that jurisdiction that they're talking about in the 14th Amendment. So that means that somebody's here temporarily, like Hamdi's parents,
Right.
Working for on a two-year work permit, never owed allegiance to the United States. Mr. Hamdi couldn't be drafted into the United States Army, and if he took up arms against us, he couldn't be prosecuted for treason. He could be detained as an enemy combatant. And so he never was a citizen. And people here on tourist visas, or even more so, people here illegally who never had authority to be here in the first place. But giving birth on U.S. soil doesn't make of their children citizens. How we arrived at this common notion is really a rather bizarre story. The framers of the 14th Amendment all say it applied to this broader owing allegiance jurisdiction. The first Supreme Court cases to take it up said, yeah, that's right. The first legal treatises to be written in the 1880s said it means this complete jurisdiction. There's a case in 1898 by the Supreme Court called Wonka Mark. And this involved the child of a permanent lawful Chinese residents. And the Supreme Court's decision, and you can sympathize with why they issued this decision. We had entered into a fairly despicable treaty with the Chinese emperor that deprived Chinese immigrants of their human rights to immigrate. We refused to recognize that they could ever renounce their allegiance to the Chinese emperor. And so these folks had come here, they had established permanent residence, they were here lawfully, they had done everything we permitted them to do, consistent with the treaty, to demonstrate their allegiance to their new sovereign, their new country. And so the Supreme Court said in those contexts, their children will be citizens by virtue of the 14th Amendment. Now, it did it with language much broader than that said they were born here, therefore they're citizens. For the next 50 years, nobody took the broader language as dispositive. It was, that case was limited to its narrow facts. So in the 1920s, for example, Congress extends citizenship to all Native Americans born on U.S. soil. Well, if the 14th Amendment had already mandated it, that act of Congress is unnecessary.
Sure.
In the 1950s, we have a program with Mexico, the Braceros, the first guest worker program.
Right.
Their children were not deemed citizens here. And when the Braceros moved back to Mexico, they took their kids with them because nobody understood that they were citizens yet. Sometime since the 1960s, though, this notion that just mere birth is all you needed started to take root. And I've been debating this issue now for several years, and I have challenged every person who's taken the opposite side of me. Tell me what it was that led to this new notion. And there's not an executive order, there's not a court decision. We just gradually started assuming that birth was enough.
Yeah.
And I think part of it is the loss of our understanding of the language that the framers of the 14th Amendment used. By the 1950s, 1960s, subject to the jurisdiction has come to mean you got to obey our traffic laws when you're here. And
Right.
the older notion, this bifurcated notion, was lost on us. And so then with this new assumption, people would look at the text of the 14th Amendment. They wouldn't question it critically. They just would take what they thought the language meant. The Article 1 of the Constitution gives to Congress what's called plenary power to determine policy judgments about naturalization and the levels of immigration. And the reason the founders did that was they understood that immigration policy is at root a fundamental policy discussion. How many people can we absorb from different parts of the world, and bring them into the American understanding of the role of self-government? And people have tried to tag that with, well, they want white Europeans rather than Asians or Latinos. That wasn't it at all. They wanted people coming from countries where they had grown accustomed to governing themselves, because it's much easier to assimilate. If you have wholesale migration from a despotic form of government, you have people that have habits that rose up in despotic regimes, it's much tougher to assimilate them to self-government and participatory democracy. The same thing with illegal immigrants today. Many come from South and Central America. The first thing that they do to come to the United States is break the law. And then they continue to live in the shadows, law breaking by definition. And the notion that the primacy of the rule of law to our system of government kind of goes out the window. And it's a very dangerous thing. And then there's a different dangerous aspect of it as well. They become preyed upon by coyotes at the border or just thugs who know that they won't report the crime for fear of deportation. And that undermines their commitment to the law as well, in a devastating way to them as well as to us. And then you get businesses that foster and play off of this, because they are able to get cheap labor. And it's not because they're paying them less than the minimum wage, because they got all sorts of tax returns, and that will come out. Where their benefit comes is they now have a workforce that won't sue them when they're fired.
There's any number of benefits.
That's right.
Sure.
And yeah, you step back and ask yourself, with all of the pro-expansion of immigration forces, the civil rights communities or what have you, and big business that claims they need more labor,
Right.
that's a combination that could get any bill through Congress in 5 minutes if they wanted to increase the level of legal immigration. And you have to ask yourself, why hasn't that happened? Because people have a vested interest in having an illegal immigrant population and a subclass that generates it. Thomas Jefferson talks about immigration in very favorable terms. What they were trying to do then is populate a continent so that it will withstand European pressures to take us back over again and what have you. The dynamic has changed now. And what we've done by having very low quotas on legal immigration, and then turning a blind eye to a massive illegal immigration, you create this subclass, you create this extraordinary drain on our social services that is bankrupting most of the state and local governments that are in the path of this migration wave. You foster both an entitlement mentality, but also ignoring of the rule of law. And the legal immigration patterns of the last century were tough enough to assimilate without losing the rule of law as well. And we are doing that. we are embarked upon a very dangerous experiment. You've got some estimates 12 million, others over 20 million people who are here illegally.
Bear Stearns report.
Yeah, who still consider their primary allegiance to be their home country, whether it's Venezuela or Nicaragua or Mexico, or Southeast Asian countries who are coming either directly through the ports or first through Mexico and then across the Mexican border. If we were to end up at war, an economic or a military war with any of those nations, the number of people here that still feel their allegiances to that prime country is a very dangerous thing, it seems to me. And it's not because they're people of different color or different language or different origin. It's because they're people that still owe allegiance to a different sovereign. They never have become part of our body politic, our government by consent, to use the language of the Declaration of Independence. And we ought not to be surprised that they owe their allegiance. If I were caught up in France and we ended up at war with France, I would still owe my allegiance to the United States, and I'd be doing everything I could while there to make sure my country, prevailed. But there's something much more insidious going on both sides of the political aisle that really angers me, because I think it is a repudiation of all that America stands for and all that is good of what we stand for. And it has this uncanny reflection of the arguments made in the old slave South. On the one hand, you've got the Democrats, who are the social welfare party. And the longer you have huge groups of people that rely on government entitlements, the more political power the Democrats can gain from that. So they have a vested interest in keeping a subclass population. The Republicans, or the big business wing of Republicans, have this vested interest in having not a new labor pool, but a new illegal labor pool, because of the way they can take advantage of them and treat them almost slave labor. And the arguments made by the Chamber of Commerce and the Wall Street Journal have an uncanny parallel to the arguments made by John C. Calhoun and the old defense of slavery, and it's, our economy depends on this and what have you. And it is a travesty that those two positions have gained enough majority support to force the government to ignore our immigration laws. In 1776, Thomas Jefferson drafts a version of the Declaration of Independence, his early draft, that criticized slavery. They force him to take that language out, but the idea shared across the founding generation, North and South alike, was that slavery was a necessary evil to be abolished as soon as possible. By the 1820s, John C. Calhoun and others are arguing that slavery is a positive good. It's the foundation, the economic foundation of the South. You pull the rug out from under it, the economy is destroyed, and it's worse for whites as well as for blacks. And they start making this economic argument in defense of slavery, and that takes root, and it lasts with us for generations. And I think what the Wall Street Journal's position and the Chamber's position is nearly identical to it. Agriculture would just be brought to its knees if we had to pay the prevailing wage, and we had to, suffer all the threats of lawsuits, if we, and all the other things that go with it. They've got a docile labor pool that they are able to put to bear to generate either greater profits or lower consumer prices on agricultural goods. And that's, I think, fairly despicable. But also a function of this idea of equality, that everybody has to come together and agree to the kind of government they're going to have. So the only legitimate government you have is one grounded in consent. So you have human rights, natural rights that you have as human beings, and then you have a government that some portion of human beings decide to create by consent among themselves in order to protect those human rights as best as they think possible. And what we do in the United States might be different than what they do in Canada or France or Mexico, but the people in each of those countries come together to try and decide what works best for them. It's consent of all concerned. To say that I have a human right to insist that you accept me as a member of your political community violates the notion of consent from our side. And when I have then birthright citizenship, that means I can illegally enter your country, give birth, and that demand entry into your political system by virtue of an illegal act. That's unilateral claims to entitlement to citizenship, rather than what our founders did, which was this notion of mutual consent in order to create the political regime. It doesn't violate your human rights to say, I'm not going to have you as part of my political regime any more than it violates your human rights for me to insist that you accept me into yours. We can no more say in a statute of Congress, everybody in Mexico City is now citizens. If I were them, I would say, wait a minute, who made you our master? Well, what they're doing is the reverse of that. Everybody in Mexico City that comes to Arizona demands citizenship, and you have nothing to say about it. For a member of Congress to be as ignorant of the history of the Three-Fifths Clause as Representative Jackson was astounding to me. The Three-Fifths Clause was actually a clause designed to aid slaves by giving less power to the slave owners than they otherwise would have had. And it was not all blacks were treated as three-fifths and all whites were treated as whole persons. It was if you were slaves, your population, three-fifths of the population counted for representation purposes, because if it counted you entirely, you weren't voting, your master was. The master would have greater power in Congress and therefore make it more likely that they would prevent an abolition of slavery. And if you go back and you look at the debates and what they were trying to do, they were trying to create a government that would recognize the principle of equality, that would compromise with an existing institution while they tried to get the government established, so that in the long run, the possibility of getting rid of slavery would be real. And the last thing you wanted to do was give representation to the Southern leaders based not just on their own votes, but on the voting power of the entire slave population. It would be hard to ever abolish slavery. And that's all it was. But people that have different vested interests in trying to say this was a racist founding like to ignore that, and they completely distort what that clause is there for.